Well, welcome to everyone to this conversation with Ambassador Petru Dumitriu, and really a great showing. A lot of people who have connected through various media. Welcome to you all. Petru, welcome to this webinar discussion within our common DiploFoundation. It's also Diplomacy Light podcast that will be later on released as well as a recording. The topic of our discussion is the newly formed Board of Peace, something that was just announced in Davos, and it draws its roots from a UN resolution. But first of all, Petru, welcome to this conversation, and thank you very much for coming and for starting this conversation with an excellent blog post that you had it. Petru, welcome.
Thank you very much, Lupso, for the invitation, and I thank everybody for the interest. Of course, I see the interest is on the issue, not on necessarily on my article or my presentation, but still, it's good to have a collegial discussion on this issue, which is quite important and raised a lot of discussion around the world.
Absolutely. Petru, you are a diplomat, a Romanian diplomat. You were Director General of the Department for Multilateral Affairs. You've been focused on the UN for a very long time and in multilateral in general. You were Inspector of the Joint Inspection Unit of the United Nations, for which you were elected by the UN General Assembly. Your PhD is on UN reform, and I'm sure that in writing it, you didn't think that perhaps this will be the ways that they might be inclined to reform, did you?
Well, to be honest, when I started my PhD thesis, I was in my first years as a diplomat in New York, and I thought I have a magic solution for the problems of the UN. And after 6 years of work, I realized that I was back to square one, and I was trying to develop a different perspective on what it means United Nations reform.
Well, taking us there in what it might mean in today's day age. I mean, it seems that, to draw on, well, Lenin, but I think it's relevant. He said at one point, I think, there are decades when nothing much happens, and then, well, I'm paraphrasing, months when decades worth of historical material is happening. We're in Canadian Prime Minister Mark Carney's words, it's a rupture of the international system. It truly is. And this is one element that we're discussing right now. But it's important for diplomats like us, others like us, to maintain a degree of objectivity and to maintain a prism that is legal in this sense, and the root of the framework of our discussion will be such a legal analysis of the Board of Peace. Before doing that, let's just briefly show why it is a hard job to do. I will share just briefly the logo of the Board of Peace. I don't know if everybody can see it. This is the logo as it was formed. It is an image created by someone of the Western Hemisphere and really North America, but it's not a map of North America that I know of, at least. I don't know. There's this line that is going, and the base and although it is slightly transmuted, if I can say diplomatically. The Great Lakes are somewhere below this line. I don't know what exactly it presents. So this is just to give us an idea that this is a hard balance to keep when analyzing these kinds of things and maintaining that objectivity. But we need to do that, exactly that. So with that, let me kind of ask you, because your analysis really of the proposed board deliberately brackets the political motivations and the personalities. Why did you think it was important to begin with from this strictly legal standpoint?
Thank you. That's a very important question. I'm glad to explain it, because there have been more than one reason to do that, to prefer that approach. First of all, the public opinion is more divided at present than ever before. The power is personalized. We are less talking about countries. We are talking more about personalities. And that is from the perspective of of a diplomat or international lawyer is not something very good, because that may change and alter the objective judgment. Of course, I have to say I do not challenge the role of political leaders in history, although history overemphasized the role of some important statesmen, either by glorifying them or by demonizing them. But again, the assessment that we may need to make good decision may be disturbed or altered by this kind of emotion. I'm a supporter of X, or I'm not a supporter, and that's alter the objectivity. Also, the media is contaminated with fake news, with propaganda or bias. We put that on the shoulder of the technology, but I think it's not fair, because behind technology there are people. The point with media is that then can push the decision of political leaders in the wrong directions. We remember the early 90s, where we talk about the CNN factor in the decision-making of the Security Council. Then I do not challenge the role of masses in history either. But people are called to vote only every 4 years at the best. So in the meantime, as you said, many things can happen, and the masses and the people and the democracies, they don't have a voice, and they are just witness of important events. The issue of the Board of Peace in Gaza is a hot issue. It follows a long series of hot issues originating from the same source. Against this background, I did not want to venture myself into the slippery slope of political speculation. Everybody does that. We could make a political speculation for hours, but I wanted to avoid that. You remember, politics is the art of the possible, as Bismarck put it at his time. The corollary of this maxim is that everything is possible in politics. So again, this is one more argument to abstain from political speculations. And I focus my analysis on only 3 legally relevant documents only. And to be honest, I didn't know this logo you showed to us at the beginning, because that would have influenced a little bit my own judgment on the issue. So relevant documents, the rest is not silence, the rest is noise, which should not be seen as that my analysis is blind from the political perspective. I will use another famous maxim: law is the concentrated expression of politics. So even if we are talking about law, we're talking about political will as well.
Yeah, and to maintain still a narrow framework, we're talking about international law here, because I mean, we can even, you mentioned every 4 years, that's speaking of democracies and political systems, but our focus necessarily is on international law, which will be important as well when we get below and into a slight analysis of both the Security Council resolution, which is the frame out of which the Board of Peace comes from, but as well looking at the charter itself of the board. So you're right that the Board of Peace is compatible in principle with international law. Where can we draw the line, the legal line, between what an autonomous organization under international law is and a delegated enforcement mechanism?
What I will express is my opinion. You know that one of the things related to law in general and to international law is the interpretation. So in my opinion, the Board of Peace, as placed in the current context, it is both autonomous and delegated. It is an autonomous organization by its own charter, which is drafted in the form of a treaty among states. So it can exist as such, and in principle, it can exert its mandate anytime, anywhere, as long as it acts in accordance with international law. But it is also a delegated peacemaking, peacekeeping, peace building, and even peace enforcement mechanism. If we look at paragraph 7 of the resolution 2003, I mentioned here all categories of UN operations as they were defined in the Agenda for Peace of Boutros Ghali in the early 90s. So, because indeed what we have there, it's a very rich package. Then the legal lines, it's not just one legal line. The legal lines are double-folded. First is the general obligation to act in accordance with international law, which included the United Nations Charter. And secondly, it is the specific obligations to act in Gaza according to Resolution 2803, which, as we know, includes also a deadline. So we don't need necessarily to have a clear line, because we have two options, two views, two interpretation that makes the Board of Peace as such in itself a legal undertaking.
So, going directly into that charter, Article 6A states that the board possesses, and I quote, possesses an international legal personality, end of quote. This really echoes the operative paragraph of this treaty that you mentioned, of UN Security Council Resolution 2803, of there being an international legal personality. But should the international legal personality in this case be understood as original or derivative? And if derivative, what is the proper legal route? The Board of Peace Charter, the Security Council Resolution 2803, recognition by states? And finally, if I can add one more to that, is if recognition of states is a factor, was the photo op of signing ceremony in Davos a performative act to demonstrate recognition by other states?
Yes, good question. And I don't want to be suspective of using in excess what we the diplomats call quite with some pride constructive ambiguity. But indeed, I would say that the reasoning I used to respond to the previous question is also adequate for this one. The international legal personality of the Board of Peace is, in my opinion, first of all, original. Why? Because it satisfied the legal requirements to be seen as an international organization with legal personality. It is constituted by the collective will of a number of sovereign member states and implicitly recognized as such. The Board of Peace could have had legal personality even without the recognition and authorization of its mandate in Gaza by the Security Council. We know a lot of, let's say, I'm overstretching a little bit the analogy, but there are so many NGOs that they do have a legal personality. They go in some countries to solve, to contribute to the settlement of some conflicts between, let's say, tribal or ethnic groups, and they do not need the authorization or a mandate issued by the Security Council, simply because they serve a good cause and they respect international law. The resolution has double effects. On the one hand, it strengthens the Board of Peace by taking it at the umbrella of the United Nations. That's clear, and that is the most important thing that resulted from the analysis of the document. On the other hand, we should see that the resolution limits the mandate and power of the board territorially and chronologically. So the resolution is for one specific territory, and there is a deadline for the exertion of the mandate. Now, so that is the originality, the fact that it's original. On the other hand, if we go deeper into the complex nature of the Board of Peace, we may say that its legal status is equally derivative. Why? Because it is rooted in the recognition of the states who have adhered or will adhere to its charter, and derivative from that recognition. Because after all, without other member states, the board would not have been an international organization. So again, I think both perspectives you described are valid in the case of the board.
the thing is that the Security Council resolution focuses on Gaza, and there's no mention of the word Gaza basically in the charter of the Board of Peace. So Security Council Resolution 2803 really is central in your text, and if we're talking about derivative, that would be the logic that the focus is on Gaza. But so, from that point of view, do you see it as a strong act of constitutional authority by the Security Council, or as kind of a minimalist endorsement that leaves too much undefined? Including, I mean, if it draws its authority from the Security Council resolution, which focuses on Gaza, you have a charter and a Board of Peace that really, at the moment, is not necessarily focused just on Gaza.
Yes, that is not an easy question, and because the whole perspective on this particular Board of Peace as a new entity is related to the resolution 2803. We don't have to repeat it, that it's essential from the point of view of indicating the legal status of this board. But we should go further and see that it contains a detailed mandate for the Board of Peace in the implementation of the comprehensive plan of peace. So we do have something that the United Nations is doing, is trying to use all means to maintain peace and security at international level. It describes a mandate of the Board of Peace, even if there is no, let's say, equivalent of language in the charter of the board. But let us make this analogy between the charter of the United Nations and the constitution of a country. So I don't think in many constitutions of democratic countries there is a reference, a direct reference to the United Nations Charter. But there is an assumption that as a member of the United Nations, those countries will observe the stipulation of the Charter. So this is why the resolution is more important than a minimalist endorsement. And also, a resolution is a resolution, is a text. We know the resolution are negotiated, there are compromises. I don't know to what extent this resolution was really negotiated among diplomats, or it was presented as a sort of ex cathedra document. But some member of the Security Council said that the language of the resolution could have been more explicit. It is true, but those objections do not make the resolution a minimalist endorsement. The resolution keeps its entire power. And then there is, it is the occasion to say something that I didn't say in my article. It is the preamble of the Charter of the Board of Peace. This preamble brings a strong statement, that a strong argument that justifies the usefulness and the legitimacy of a new initiative of peace. Whether it comes from one country or from a group of countries, it is important to have a peace initiative in the Middle East. The Charter does not name, indeed, the Palestinian-Israeli conflict, but if you see the preamble, you realize that this is a long series of notes on the past failures of all peace initiatives in Middle East. So it is the answer to your question is that it is essentially is not just a minimalist endorsement.
I think it will really depend on how it goes from now on, because the resolution relies on periodic reporting, and I think that this is one of the key things. Is there going to be periodic reporting, and what form they're going to take to the Security Council from the Board of Peace? But is this, in your opinion, a sufficient safeguard to preserve the Security Council's central role in this and broader?
I remember, and I think it is the case for all students that are, are taught about international law. The first question that is debated by all distinguished authors is the question: is international law really law? So, given the differences from the enforcement means that the state might have and the international community or the international organization does not have it. But let's look at the facts. And the facts, as you say, as we know, they are stubborn. periodical reporting is the usual, is the standard formal request of the Security Council for all situations and topics on its agenda. So if you have a look at the recurrent debates of the Security Council, you'll see that there is at least one report of the Secretary General, which is the description of the progress review in a certain situation, in a certain conflict, etc. It is true that member states can use their own information, which they can share, including in the form of letters sent to the Security Council. So there is this report, and there is the information originating from member states. If I want me to give an example, I remember I was in New York when the genocide took place in Rwanda. So the overwhelming majority of the United Nations, including a majority of the members of the Security Council, did not have information about what is really happened in the field. And it was even worse because the government of Rwanda was a non-permanent member in the Security Council. So what I'm saying here is the Security Council is having more instruments to check the information, to check the progress in the field, other than the report of the Board of Peace. So we have to take it that the report produced by the Board of Peace should play the same role as the report presented by Secretary General, despite the fundamental difference of status between the Secretary General, which is serving the entire international community, and the Board of Peace, which has a particularity in terms of who leads it. It is possible that even if the reports are not very accurate, if they are misleading, I think nothing prevents the supply of impartial and objective information to the Security Council by everybody else, member of the board, member of the Security Council, or simply members of the United Nations. So the normal procedure that does not provide more as safeguard for the quality of the reports.
I mean, and let me pause at the moment really to invite any comments or questions from our audience and participants. I think that we have a lot of knowledgeable people, diplomats here as well. So please, if you do have any questions or comments, type them in. I'm together with Diplo colleagues monitoring the chat, so we can bring it into this conversation. But so let me challenge you, Petru, as well as our participants. Should we be concerned about the Gaza case itself or about the precedents itself? Because some have argued that the Board of Peace could become a template for bypassing UN peacekeeping in future crises. We can have, again, this process of plurilateral or unilateral, instead of going through the regular channels of multilateral diplomacy, General Assembly, Security Council, certainly. Is this a precedent that is the precedent perhaps itself more concerning that it sets, or is it really concerning in and of itself that the Gaza situation is not being perhaps properly addressed?
If we look back at the history of the United Nations, we will see that it is marked by innovation and adjustment to the local, to the regional, and to political circumstances. United Nations underwent fundamental changes, geopolitical changes, like the decolonization process, the Cold War, the end of the Cold War, the advent of the technological era, and without amending the charter, they managed to adjust and use what they have for having in mind the same charter. And then peacekeeping operations themselves were an innovation in the gamut of actions taken by the Security Council. That nickname that is given to peacekeeping operations, Article 6.5. It was a compromise, it was an innovation at that point. And now we come to the Gaza, we come closer to Gaza. to the Gaza situation. The first such a peace operation, the United Nations Truth Supervision Organization, was implemented in Middle East. And then the first major peacekeeping operation, as we understand it today, the United Nations Emergency Force, was established in 1956 following the Second Arab-Israeli War. So these innovations were useful, and they were implemented by the countries with some conviction that they are doing the right thing. The concept of peacekeeping has evolved, in itself has evolved constantly, from mere buffer zone supervision, like the force in Cyprus. They just stay at the border between the two divisions of the island, and they went to complex operation involving transitional administration, the reconstruction, demobilization, organization of elections, etc. So it was a whole history of innovation. And then we are getting even closer to Gaza. The conflict is still there. The Palestinian problem has not been solved 78 years after the partition of Palestine. So the usual method used by the United Nations did not work. And one major reason is that actually Israel, after seeing the state of Israel, saw the birth certificate of that state signed by the United Nations in 1948, then later on declined to cooperate with the United Nations and refused the authority of the United Nations. And in Palestine, with each year that goes by, the problem is aggravating. So definitely, in my opinion, the diplomats should be more concerned about the Gaza case than fearing possible consequences of a precedent of an unusual move. One should frankly put the question, what can be worse for the Gazawi people after what has happened in recent years? So in other words, any attempt seeking to settle the situation is a positive one, whether or not we like the circumstances. But we have so many governments and distinguished statesmen that try to do something, and we have Nobel Prize bestowed to people who tried to advance the peace process in Palestine. It didn't work, so why not trying something new?
You emphasize, I think, as does the Security Council Resolution 2803, that any international administration must be temporary and oriented toward Palestinian self-rule. What concrete benchmarks then should be used to assess whether this principle is being respected in exactly this way that you mentioned? If it really is an attempt to solve the situation in Gaza, how do we try to evaluate its success? For instance, even let's say a future Nobel committee.
Yeah, well, we know very well that at the horizon, somebody also is looking at such a perspective. But again, I'm back on Earth. I'm back with the two documents in front of me. Resolution 2803 not only welcomes the comprehensive plan to end the Gaza conflict, but includes the plan. And if you look at the plan in itself is a combination of benchmarks in terms of security stabilization, humanitarian assistance delivery, institutional reforms of the Palestinian Authority and other Palestinian institutions, and the redevelopment. If you look at operative paragraphs 4 and 7 of the resolution 2803, or paragraph 9 and 15 of the comprehensive plan, you will see a fair description of concrete benchmarks. Of course, other paragraphs, in particular those referring to the future economic development of Gaza Strip, might be, as they are, aspirational and over-optimistic. But the institutional objective of the plan could be achieved if indeed the commitment of all parties remains firm. And when I say all parties, I say not only the United States, but also the other members of the board Israel and Egypt with the particular interest given their proximity, and the Palestinian Authority itself. So there are benchmarks in our opinion. If everybody acts in good faith, we have reasons to hope. We are not sure about the success, but we have reasons to hope.
Thank you. And well, there is hope, and we need to be optimistic as much as we can be. We need to be objective as well. You do express concern in your article, in our conversations, that really the concentration of powers in the chairman of the Board of Peace, who in this charter has final authority on interpretation of its administration, holds unilateral powers over membership, dissolution, subsidiary organs, vetoes. This may sit uneasily with principles of accountability, of due diligence, of due process, of collective responsibility. From international law perspective, again, this is our perspective. Where do you see the line between acceptable executive discretion in exceptional transitional settings and a concentration of authority that begins to pose legal or institutional risks?
Well, here I have to, of course, as I hope I convey that message, I'm not trying to defend some positions, but I'm trying to defend, the formal aspect of the situation, and I'm trying to defend anyway this resolution, which was a courageous resolution in the sense that at the time of such tension among the great powers, we still have a substantial resolution of the Security Council on a very sensitive issue. But indeed, this concentration of powers in the hands of the chairman is the most problematic part of the charter of the Board of Peace. It is its Achilles heel. But that is less from a legal perspective, more from a political one. But in international law, we cannot presume abuse of power in advance. The presumption of innocence is varied also in international law, the presumptions of good faith. It is a peace initiative and should be considered with the presumption of good faith. And the means to reach such possible peace is not, by threatening with the use of force, by displaying military equipment around a certain area or certain country. The benchmarks and the description of mandate indeed, justified what I say, the hope, and the diplomats should be, they are optimistic by profession. The risk is there. It is real, but one cannot dismiss the whole plan for such reason. We should not throw away the baby with the dirty water in the tub. So, and there is also, we are talking about, the risk to accountability, due process, and collective responsibility. But speaking about collective responsibility, it would be unfair to believe that the other members of the Board of Peace, other than the main initiator, will indulge themselves in the role of silent background actors in cases of breach of international law. In addition, again, coming back to the Security Council, the Security Council will examine the matter every 6 months, and it is not just a formalistic moment. The Security Council can take action. There is also the specific time limit for possible further reauthorization. But the Security Council, we know at the end of 2027, but the Security Council can, in principle, withdraw the authorization at any time. They can meet in an emergency meeting and say, okay, guys, we withdraw. I'm speaking about a purely theoretical option, but it's there in the charter. The Security Council can decide, okay, stop, you don't have our blessing for these operations, you abuse it, it's not what we meant. But I will insist not just on the, let's say, the equivalent of check and balances, but also the collective responsibility. There will be, there are already a number of members of the board, countries that expressed or even signed the charter. There will be more, I guess, in the end. So we should trust also those countries that they are not there just to align to a nice initiative. They're there to contribute to the peace process. And I'm sure they will not they will not simulate their role as a real protagonist in that board. So that would be my impression. It's not. I mean, I cannot be a prophet. I cannot grant that this will happen according to the rules approved by the Security Council, but we still have reasons to believe that the machinery that will be put in place will try to do the best for Gaza.
So if there are violations, though, where should then responsibility be attributed? To the board itself, to participating states, to the Security Council that authorized it? Does international law offer a pathway of responsibility and accountability in this sense?
Well, yes, that is something that is difficult to establish because you know, I'm thinking of an example in the past. The first time that the notion of responsibility to protect was approved by the General Assembly, and it was considered one of the possible instruments of intervention by the international community. The responsibility to protect meant that you can go in some countries without having necessarily the consent of the host government, because the host government is part of the problem. It's not having an interest to solve a particular situation of conflict. So in the case of Libya, the Security Council, for the first and the only time, they invoked the responsibility to protect in the justification of the resolution on the intervention in Libya. And then it was one of the member states that actually went beyond the lines and beyond the terms of reference for responsibility to protect operation, and that was overthrowing the government of the country. And that was seen, and the Security Council discussed the issue and established that I mean, did not establish anything. Sorry for the expression. They just noted that the terms of reference of responsibility to protect, they were not observed, and the consequence. And they indicated what country was in particular guilty for doing that trespassing. And the result was not that that country was other than been criticized in the Security Council, did not suffer any sort of penalty, but it was clear that somebody broke the rules, and the consequence was that there was no more operations under responsibility to protect because of the risk, which was manifest in the case of Libya, of doing more than it was required. So the let's say the responsibility, we cannot find the special way to deal with responsibility with a deviation from the mandate of an operation, because there are not too many means in the international law. But we could use the existing information to see to what extent and where and who was guilty for that, and then it is what the international public opinion can offer. No enforcement options, no sanctions imposed. Is just disappointed and just the insatisfaction and the criticism to that country. So I wouldn't have a sort of special response to that question. And there is also, I'm talking now about the responsibility of states. If we have to talk about individual responsibility, of course, we have the international criminal courts if the case is to use them, but we know how difficult it is also working with those kind of international tribunals. And I see you gave me one more second. I could say that whether, yes, it is true that we don't have a way to respond to violation of the rules of engagement, but then we have what it is called the erga omnes obligation under the international law. For instance, if somebody violates in the course of the operation the international humanitarian law, whether they are in the board or not in the board or just neighbors, the obligation provided in the international humanitarian law are considered valid erga omnes. And that brings me to something more specific for Gaza, in the sense that the International Court of Justice, even in 2024, identified violation of certain obligations erga omnes in its advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. So not only we have the international law in general, but we have also a specific advisory opinion of the International Court of Justice referring to Gaza, not to any other area in general, given the special status of the special situation of Gaza. I hope I responded somehow to your...
Yeah. And as we start winding down, and we advertise this an hour and a half, but I think that in today's age, an hour is enough. So I aim to finish at the hour. So last question for me, and perhaps we turn to a few questions from other participants before we close. But for me, basically, we've been looking at this continuity, and you just brought in another aspect of international law. But we've been looking at this kind of delegated authority from the Security Council. But there is another relevant aspect of international law. It draws from international humanitarian law, particularly the law of occupation, because we're talking about an occupied territory. And there are obligations under international humanitarian law, specifically on occupation, that impose what are some constraints. And so my question is, to what degree is that the case? Are there clear lines of responsibility if authority is exercised through such a delegated structure, and specifically looking at it as an occupied territory, drawing on international humanitarian law and what it says about occupations?
So in terms of international humanitarian laws, and we have the long history of application of the Geneva Conventions, I think more than anything, the Geneva Conventions and the international humanitarian law draw a clear distinction between evil and good, between wrong action and between disintention. I think we live at a time where human civilization reached a certain degree of, let's say, respectability and of respect for international law in whatever form, even if there are no, let's say, police means, to correct the behavior of a certain country, unless it is by a decision of the Security Council. What I can say about Gaza is that this new peace initiative does not imply a special ramification of international law. We have the international law as it is. There is a need to, let's say, improve the core of international treaties that are dealing with that issue of behavior in occupied territories. But I think that everything was said in the Geneva Conventions. And I think there were in the history cases when the most ferocious armies, they tried to observe, at least in appearance, the provision of the international humanitarian law. So what I would say, if there are violations, the current institutional framework is already available, including, as I said, international criminal courts, which can be seized. But there is nothing that should be inspired by the specific case of the future work of the Board of Peace in Gaza.
And I think this is a key distinction as well. Like one of the aspects that you mentioned is to keep at least an appearance, and we've seen that before. That even in some situations in the past, at least the appearance of legality has been tried to be kept. We may be entering into a field where that is less necessarily the case, but hopefully that is not. We go into some right away some touchy and hot subjects. We have a question in our chat that I'll read it out. And I'll partially answer it, providing some buffer to you, Petru, because we're good friends. The question is, how are we, from Claudia, how are we to square the fact that a sitting board member, Netanyahu, is wanted by the ICC for war crimes and crimes against humanity, committed specifically in Gaza? Now, I will share from basically the structure that I have seen latest. This is from the European Council on Foreign Relations, the structure of the Board of Peace. So you have the Board of Peace that is there, seniors, advisors to it. Then you have an executive board, and then you have a Gaza executive board. So these are two kind of separate bodies. Nikolai Mladenov plays a key role on both. But to my knowledge, at least, Netanyahu is not a part of the structure. I may be corrected. Maybe somebody else knows better. But this is the last that I know of the structure of the Board of Peace. Petru, do you want to add something? Or?
Then here we are to that particular situation where we use names of personalities instead of name of countries. So I would avoid naming the Prime Minister of Israel. I would name Israel as a part of the conflict. So what is diplomacy? Diplomacy is about engaging all parties that can bring a solution to a conflict. So engaging the main protagonist is essential. We cannot make a peace without engaging with the party that is involved in a conflict. Peace means a compromise between the interests of two parties. In that case, we are following the two-state solution in Palestine. So we have to talk about the state of Palestine. We have to talk with the state of Israel. Of course, we know how complex is that situation. We know that the resolution of the Security Council on Middle East are no longer necessarily welcomed by Israel. But again, to make peace, we need to engage Israel. We need to engage, irrespective of the situation. We need to engage all parties involved in the process. In our case, of course, now we distinguish between two different, let's say, two different political factions in the Palestinian territories, elected by the people, and one of them proved not to be following the peace. But we have a sort of collective endeavor where the Palestinian Authority accepts the dialogue with everyone else to reach the objectives of peace. So it is a difficult issue, and at the same time, okay, if there is a case at the International Criminal Court, the presumption of innocence works in all legal systems. So until we come to that point of proving that a certain statesman is guilty of something. We are dealing with the states, and that's my perspective. We have to deal with Israel. Whether there is a prime minister or another, it doesn't matter. It is Israel. We cannot make peace without Israel. And also, when we speak about major power like the United States or like Russia or like China, in the United Nations, in international law, the protagonists are the countries, not their leaders. The leaders, they form a different category.
No, you're absolutely right, and that is the reason why we started this conversation in such a manner to begin with, because it allows us for really an objective discussion, and I mean, we can all enter this with a lot of emotions. But so I see that Claudia has put a link about the acceptance, but again, this is, you're right, Petru, this is an acceptance of Israel. It's not a personal, even though the chairman makes it very personal at that level, but really the main actors here are states, and Israel is a part of the Board of Peace as a state, not the individuals in it. So I'll wait perhaps if somebody else wants to jump in with a question in the chat. But I think that we've really, I think this is the way to be able to discuss these things. This rupture in the international system, we can all be awed by it, and really I think anyone who turns on whatever news source they get, I think on a daily basis, there are things that are of a tectonic nature in the system, but we have to have frames of discussing it and analyzing it. And I think that today's discussion, Petru, has been in such a manner. So thank you very much for participating and for having this discussion. Thank you very much for providing a framework that allows it, Petru.
Thank you for your interest, and I think this is the way. In particular, I don't know how many diplomats are among those who follow that conversation, but diplomats should take on board all options of action if it is meant to serve the public good. Diplomats should be optimistic. Diplomats should listen to everyone. Diplomats should study international law, know exactly what they are talking about. They shouldn't necessarily follow the headlines, which are hasty. They are sometimes very misleading, and for most of the public opinion, they can have a negative impact. But the diplomat should stay a little bit connected to documents, connected to facts, and in particular connected with the mission of a diplomat, and in our case of multilateral diplomacy, because after all, this Board of Peace is yet another form of multilateral diplomacy. Thank you. Thank you for the invitation.
Thank you very much, Petru, and thank you to all our participants. Thank you to Diplo colleagues who were in the background, and I really want to thank them because they make it possible for us just to have this conversation and focus on that and not focus on other things. We should do these kinds of things more often, and I look forward to them, including with you, Petru, so thank you very much again. With that, let's sign it off, and until the next time. Ciao.
Yeah.